Failing to water a lawn properly or forgetting to license a dog or cat might seem like low-level violations, but they were being charged as criminal misdemeanors by most local governments in Utah. Because of this, many Utahns are turned into criminals for code violations that are not really that serious. Consider the case of the Smith family in Heber, whose dog ran off one day. Animal control picked it up shortly after, and once they paid the fine to retrieve their dog, the Smiths thought the ordeal was over. But weeks later, they got a letter from the county summoning them to court for 3 different misdemeanors stemming from the incident: for having a dog at large, for failing to license the dog, and for failing to get a rabies vaccine. The dog harmed no one, and they never realized they had committed a criminal offense, but they had to go to court to defend themselves. Fortunately for them, the judge ended up dismissing all of the charges that should not have been so high in the first place. A misdemeanor punishment is often overly punitive for unharmful property and pet offenses, but many people don't fight these types of charges in court. They simply go online and pay the fines, which is technically a guilty plea. And as a result, they get a criminal conviction on their record. This can prevent them from getting a job, student loan, or housing, which usually require background checks. This year, Representative Jefferson Moss sponsored and passed our proposal in House Bill 202 to stop overcriminalization from occurring on a local level. It requires localities to stop charging property and pet ordinance violations as criminal misdemeanors in most cases. The law allows them to still impose a misdemeanor if the offense rises to the level of an actual nuisance and is a threat to the health or safety of an individual. They can also still charge for a misdemeanor for repeat offenders, but otherwise they have to keep it as an infraction or lower. The new law also gives Utahns a 14-day period to resolve any low-level violations before they are given a subsequent citation. Before, local governments could give them a citation every single day, which becomes very costly and difficult for busy Utahns to comply with. And this could occur even when the violation was not causing harm to anyone. We worked hard alongside many Utah stakeholders to ensure this bill upholds private property rights while keeping the public safe, and most importantly, to make sure that Utahns are not unnecessarily introduced into the criminal justice system for low-level violations. For Libertas Institute, I'm Michelle Eden.